is Goodwork with SashaMeIntoLaw.com. I'm here with a legendary figure in the legal field. He smiles, but don't even be fooled by that. I'm sitting next to a man who has just been inducted into the Licensing Hall of Fame. Very big deal. He is an attorney, a litigator, fierce, committed to what he does, and also general counsel for Lima. He is Greg Battersby, and welcome.
Thank you.
And you've been teaching a lot of the seminars, but we're about to get into some of the specific points you've been pointing out from a legal perspective.
Correct.
In terms of the anatomy of a legal licensing agreement. Could you distill some points for us?
Well, the point I always make, and I have really a competition. I have all the people in the audience guess, or not guess, but make an educated guess as to what they consider to be the most important provision of the agreement. And it always comes down to one: it's termination. You know, the whole concept of a license agreement is it gets negotiated, it gets put into a file, and it never gets looked at again until there's a problem. When the problem develops and because the business has gone bad, they go to the lawyer, and the lawyer wants to know, how do I get out of this? How can I get out of that? It means they start looking at the termination provisions. So it's and there's a whole ton of other provisions in there, quality control provisions, obviously the compensation, audit provisions, but at the end of the day, you're really writing an agreement for termination. Because you have to anticipate at some point in time that the deal will end, and what happens at that point in time.
So let's talk then about the termination agreement, and we'll specifically get into the details that might possibly go into termination clause. Usually when we lawyers write termination agreements, we keep it simple. Okay, you hurt me and I hurt you, and there's a breach. We go our separate ways, and then if you want to sue somewhere, you can, etc. What's so unique in terms of licensing and how you approach that?
Well, the whole concept of licensing, licensors don't get into the business for the advances or guarantees. They're in the business for the royalty stream, which is going to get generated as a result of the relationship. The good licensors hold the licensee's feet to the fire with regards to performance. It's all performance driven. So when you write the termination provision, you want to tie it back to the licensee complying with the performance criteria. They'll have product introduced by a certain date. They'll have product sold by a certain date. You will meet minimum sales requirements. From a legal point of view, you want to make sure that the product is properly marked. If he fails to have it properly marked, you want an ability to be terminated. There's a whole line of approval processes. If he doesn't get the product approved from a quality point of view, from a market point of view, you want to write the terminator. You got bankruptcy issues where they go into bankruptcy, where you have the financial wherewithals to survive. If he doesn't have the financial resources, you want an ability. Bottom line to this whole thing is that you draft the agreement with a batch of what I call landmines in it for the licensee, and if he happens to set off one of the landmines, the licensor wants the right to get out of the agreement. Again, the licensor is in the business for making money by the licensee, working, paying the royalty, and commercializing. He's not doing what everybody anticipated he's going to do, and if he's not doing it, really well, the licensor is going to want to turn it.
Okay, so let's try to create a little bit of a balanced perspective for some of the folks that might be watching that are licensees. So to that end, how do they, well, not necessarily how do they comply, but what are the things that they can do in order to avoid that one of those landmines going off?
Well, what they have to do is, from a business administration point of view, they have to make sure they've read the agreement. It's frightening in a way when you'll draft an agreement, send it out, and you expect changes to a marketable copy coming back from counsel for the licensee. What's more frightening and bothersome to me is when it comes back signed without a change to it, which tells you the licensee hasn't read it, which means if he hasn't read it, he's not going to comply with it. So what you really want to do is make sure the licensee has to know what his obligations are. If I'm the licensee negotiating the agreement, I'm going to want the right to cure virtually every potential breach. From a licensor, I'm probably not going to give some of the breaches. I'll give a cure right for some of the breaches. As a practical matter, it's give and take. There are very few agreements which are non-negotiable, despite what the licensor may say. And a licensee has to read it carefully, make sure he can comply with the provisions, and if he can't comply with the provisions, negotiate something which makes sense for him.
amazing quality content. Seriously, it is. And what I want to do now is go into a little bit more into your career and get a lot more information. You've written over 30 books, I believe. You are the authority when it comes to licensing. Could you talk about the publishing arm when you decided that you wanted to write books, and a little more about where that journey has taken you so far?
It's been a fascinating journey of sorts. I was in-house. I was with a couple of big firms in the city, IP firms in the city. I went to Gulf and Western in 1975, which owned Paramount Pictures. That's when I first got involved in merchandising. I had done some tech licensing and some software licensing, but I got involved with merchandising. My ultimate partner, who was with me at Gulf and Western at the time, wrote an article for the Trademark Reporter entitled "The Protection of Merchandising Properties," which got published in 1979. I left Gulf and Western in 1982. I'd spoken at the first couple of licensing shows at the time, came back and there was nothing out there other than an article. So I said, maybe there's an opportunity here. We were looking to grow a practice because there was just 3 of us at the time. What better way to do it than publishing? So we actually created a publication called the Merchandising Reporter, directed to the legal aspects of merchandising. That led us to Clark Boardman, which is now West, approaching us to buy the publication, which we didn't sell at that time, but to do a book for them called The Law of Merchandise and Character Licensing. That book has been in print since 1984, I think it is. We update it annually. That led to a number of other books. We ultimately did a multimedia book with West. We did a whole series of, we do a lot of forms books for Aspen. License forms agreements, or the internet forms agreements, some litigation books. We also, Merchandising Reporter ultimately became the licensing journal. We broadened the base a little bit, and it's helped.
Wow.
It's helped.
In that vein, let's talk a little bit about social media publishing. Certainly, the magazine, and it's been a very interesting story.
Sure.
How does that affect licensing and specifically publishing also?
Social media, for me, it hasn't much. I mean, I just watched Social Network last night. I was a little bit surprised by the entire thing. It's just, I hate to admit it, I don't quite get it, but that's my other story.
And you're allowed not to at this point.
Apologize. There are a number of people at the office who spend hours on Facebook.
Yes.
I'm not one of them.
You just have them do it.
Well, having said all that, I think it certainly has its place. It's a way to certainly connect with a lot of other people. And most licensors use it and licensees use it.
Yeah, we attended a seminar with respect to licensing in the digital age.
Yes.
Great.
That's a whole different world.
Yes,
That's
absolutely.
A whole different world.
And to show, the numbers, the move is just phenomenal.
And that's really the future. I mean, it's not the future of licensing, but licensing has evolved heavily into digital areas. It's set a lot of the royalty rate trends back. People are having trouble figuring out the royalty rate models for it. But it's raised a lot of issues. It's been fun. It really has been challenging. Facebook is another story.
So we've covered your background. We've gone into your publishing. We've gone into licensing. Now let's take a little bit a different direction, which is the legal profession and young lawyers. As a young lawyer myself, and certainly young lawyers that will be watching this, the market is crazy now. A lot of lawyers coming out. You're hearing about lawyers that are suing their schools because they're not able to get them jobs that they promised, and whatever the case might be. What's your advice now with the practice of law for young lawyers?
I think you really need a specialty. And I think the days of the general practitioner are gone. I mean, there's obviously some around, but I think you tend to specialize into subspecialties. I'm an IP lawyer. I'm a patent attorney by training, but it's you're doing a merchandising deal. I'm not sure that they would generally want to deal with a pure patent attorney. And obviously, they'll understand the issues, but you get into the business part of the deal. And it's getting to the point where if If you specialize in merchandising, you may want to be a specialist in the toy side of it, or the apparel side of it, or the digital side of it. Because they're different deals. And when you're writing the agreement or negotiating the agreement, you really got to understand the industry you're working with, particularly on the licensor side. Because you may do a T-shirt deal today, tomorrow you're going to do a toy deal, the next day you're going to do a direct-to-retail deal, the day after that you're going to do a video game deal.
And all within the same industry. Or you're talking about different
from the
industries.
licensor, from the studio lawyer, I'm doing that. Having said all that, every deal is going to be different. And the things you're looking for in those deals are going to be different. I think I'm very open to everybody, but to the young lawyer in particular, ask questions. I mean, don't be afraid. I look back and I think when I was 30 years old or 35 years old, I'm sure I felt I knew everything. I mean, I really did. And the truth of the matter is, I'm appalled at how much I didn't know. And even I'm 64 years old, and I'm still appalled at how much
I always love that. You go back and you say, oh, especially for me, I remember in my teen years thinking I knew it all. And then I go back and say, what were you thinking?
Well, it's funny, it doesn't end. The learning process never ends. I give seminars, and I do a lot of seminar work. Probably given 200 or 300 seminars over the years. I try to make them interactive because I really try to get the audience participation. Because I walk away learning stuff myself. The learning process for a young lawyer should never end. It really should. And it's not just the formal process of CLA or the process of going back to law school for an LLM, but it's, the older lawyers of the world really kind of do know something. If you've been through this before, a lot of the things we put in our agreements, I can point to the scars on my back, as to how they got there, because you learn lessons. And that's the biggest issue. You have a baseball pitching machine company, and I tell the people there all the time, it's okay to make a mistake. Don't make it twice. And certainly don't make it 3 or 4 times. But the way you do that is you learn from your mistakes. And at the practical matter, you shouldn't be afraid to ask questions. I mean, you're going to find that lawyers my age are generally happy. We're happy to know the younger lawyers are. But there is a generational issue, and I'm sure when I was 30, I knew it all.
Yes, no joke, right?
It's true.
Well, thank you so much. I mean, it is an honor, really, to do this interview from so many angles, both from John's perspective, certainly, but from the legal perspective, an attorney also, and the wealth of experience that you bring to the table. Thank you for sharing. I'm sure everyone watching this will enjoy. And thank you so much. Have fun at the conference because we intend to.
Thank you.
And check out a lot of the brands. So thank you.
Enjoyed it.
Thank you.
Good luck.